Attorney Adam Schmalze here again at my office located at 47 Harvard Street in Worcester, Massachusetts. Today I want to talk about 209A protective orders, also known as restraining orders. There are two types of protective orders that one can get in Massachusetts: a 209A abuse prevention order and a 258E harassment order. I'll cover harassment orders on another video, but both of these orders are civil protective orders. And civil protective orders are designed to put a barrier in between two people with the obvious goal of trying to prevent some sort of an abuse or in some cases an annoyance. What's important to note here is that there is a major distinction between a criminal case and a civil order. In a criminal case, the complaint is brought by the prosecution and the standard of proof is beyond a reasonable doubt. A criminal order has the possible effect of taking away a person's liberty. For example, sending somebody to jail. A civil order is generally brought by an individual or an organization with the primary goal of recovering some form of compensation or preventing some sort of act. The standard of proof is preponderance of the evidence, which essentially means that the judge has to be convinced that 51% or more of the complaining party's complaint meets the statutory requirement for the order. A civil restraining order has the opportunity to cause a person to act or refrain from performing a certain act. And in some certain cases, the same risk of loss of liberty, but that's a conversation for another day. Here's where it gets confusing. When a protective order is put in place, that order is civil in nature. But if the protective order is violated, it will trigger a possible criminal case. That is the threat that makes protective orders so effective. A criminal conviction on either the Massachusetts 209A abuse prevention order or the 258E harassment order can trigger a maximum penalty of up to 2.5 years in jail, which is the maximum amount of jail time that a person can get on a single charge in district court. So, the abuse prevention order, it's governed by Massachusetts General Laws, Chapter 209, Section A, and practically speaking, this order is there to protect a person from one of three types of abuse between family or household members. That's what the statute says. The first type is causing or attempting to cause physical harm. The second type is placing another person in fear of imminent serious physical harm. And the third is causing another person to engage in involuntary sexual relations by force, threat, or duress. A family member or household member does not necessarily need to be a person who lives in your home today or who you're currently in a relationship with. This would also apply to divorced couples, couples who are dating each other or who have dated each other previously, couples who have a child together, and even people who used to live together, depending on the time when the complaint was filed and the other person vacated whatever premise they shared together. It could also apply to people who are related by blood or related by marriage. Now, when a person seeks to have a restraining order put in place on behalf of themselves or on behalf of a minor, which you can do, they first have to file an affidavit with the court. This affidavit is so important because it has to describe with specificity the reasons for the request. It is the first thing that we look at on the defense side because it's a signed writing, it's submitted under the pains and penalties of perjury, and if it does not describe an event that meets those three types of abuse, the judge might not issue or continue the order. Now, what exactly are you asking the court to do with this order? Well, you can ask the court to order a person to refrain from abusing you. You can ask the court to order a person to refrain from contacting you. You can ask the court to order a person to stay away from your household, your job, or maybe even your school. And you can ask the court to make that same order for a minor child. Now, these complaints can be filed in the district court, the superior court, the Boston Municipal Court, or the probate and family court. But if a child is involved, the district or superior court or the Boston Municipal Court might make certain orders with regard to visitation, but they're going to leave the major contested visitation issues to the family court because that is where those issues typically are heard and that is where they belong. A person who the order is against must be served with the order. because the defendant has a right to defend against it. That's due process. After the initial order is made, there will usually be a hearing within 14 days for the judge to decide whether or not to extend it. The first order is the emergency order. The 14-day is the extension order. Now, if the court decides to extend the order, it will commonly be extended for 1 year. I've seen judges in my practice extend them for a lesser amount of time, and I've seen judges extend them for a greater amount of time. The court can extend a no contact order, a stay away order, a no abuse order, or all of the above. But violating any order of the court with a protective order could result in jail time. If you're seeking an order and you choose to testify, you can be subject to cross-examination from the other party or that other party's attorney at the extension hearing. If you're defending against a restraining order, you have the opportunity to be heard or to cross-examine the other party if that is a part of your strategy. Either way, an experienced attorney can help you through the process and help you put together an effective strategy to meet your goal, whatever that may be. If you have any questions, email me directly at litigatema@gmail.com or call me at 774-314-9124. Thank you.